Okay, so got the phone upside down. Or not. Sorry about that. But we just researched the issue of this case. The question before us is whether preventative detention of juveniles pursuant to this section is compatible with the fundamental fairness required by due process. That's the issue. That's the question for the court. Two separate inquiries are necessary to answer this question. First, does preventative detention under the New York statute serve a legitimate state objective? And second, are the procedural safeguards contained in the Family Court Act adequate to authorize the pretrial detention of at least some juveniles charged with crimes? Preventative detention under the Family Court Act is purportedly designed to protect a child and society from the potential consequences of his criminal acts. When making any detention decision, the family court judge is specifically directed to consider the needs and the best interests of the juvenile as well as the community. In Bell v. Wolfish, we left open the question whether any governmental objective other than ensuring a detainee's presence at trial may constitutionally justify pretrial detention. As an initial matter, therefore, we must decide whether, in the context of the juvenile system, the combined interest in protecting both the community and the juvenile himself from the consequences of future criminal conduct is sufficient to justify such detention. The legitimate and compelling state interest in protecting the community from crime cannot be doubted. We have stressed before that crime prevention is a weighty social objective, and this interest persists undiluted in the juvenile context. The harm suffered by the victim of a crime is not dependent upon the age of the perpetrator, and the harm to society generally may be greater in this context given the high rate of recidivism among juveniles. The juvenile's countervailing interest in freedom from institutional restraints, even for the brief time involved here, is undoubtedly substantial as well. But that interest must be qualified by the recognition that juveniles, unlike adults, are always in some form of custody. Children, by definition, are not assumed to have the capacity to take care of themselves. They are assumed to be subject to the control of their parents, and if parental control falters, the state must play its part as parens patriae. In this respect, the juvenile's liberty interests may be in appropriate circumstances be subordinated to the state's parens patriae interest in preserving and promoting the welfare of the child. New York Court of Appeals, in upholding the statute at issue here, stressed at some length the desirability of protecting the juvenile from his own folly. Society has a legitimate interest in protecting the juvenile from the consequences of criminal activity, both from potential physical injury, which may be suffered when the victim fights back or a policeman attempts to make an arrest, from the downward spiral of criminal activity into which peer pressure may lead the child. The substantiality and legitimacy of the state interests underlying this statute are confirmed by the widespread use of judicial acceptance of preventative detention for juveniles. Every state, as well as the United States and the District of Columbia, permits preventive detention of juveniles accused of crime. A number of model juvenile justice acts also contain provisions permitting preventative detention. So that's just like comparing jurisdictions. And the courts of 8 states, including New York Court of Appeals, have upheld their statutes with specific reference to protecting the juvenile and the community from harmful pretrial conduct, including pretrial crime. In light of, so that's all case law. It's not binding, but it's relevant. In light of the uniform legislative judgment that pretrial detention of juveniles properly promotes the interests both of society and the juvenile, we conclude that the practice serves a legitimate regulatory purpose compatible with the fundamental fairness amended by the Due Process Clause in juvenile proceedings. Of course, the mere invocation of a legitimate purpose will not justify particular restraints and conditions of confinement amounting to punishment. It is axiomatic that due process requires that a pretrial detainee not be punished. Even given, therefore, that pretrial detention may serve legitimate regulatory purposes, it is still necessary to determine whether the terms and conditions of confinement under that section are in fact compatible with these purposes. A court may decide whether the disability is imposed for the purpose of punishment or whether it is but an incident of some other legitimate governmental purpose. Absent a showing of the express intent to punish on the part of the state, that determination generally will turn on whether an alternative purpose to which the restriction may rationally be connected is assigned for it and whether it appears excessive in relation to the alternative purpose assigned to it. There is no indication in the statute itself that preventative detention is used or intended as a punishment. First of all, the detention is strictly limited in time. If a juvenile is detained at his initial appearance and has denied the charges against him, he is entitled to a probable cause hearing to be held not more than 3 days after the conclusion of the initial appearance or 4 days after the filing of the petition. We call those SLAs. Whichever is sooner. If the family court judge finds probable cause, he must also determine whether continued detention is necessary. Detained juveniles are also entitled to an expedited fact-finding hearing. If the juvenile is charged with one of a limited number of designated felonies, the fact-finding hearing must be scheduled to commence not more than 14 days after the conclusion of the initial appearance. If the juvenile is charged with a lesser offense than the fact-finding hearing, he must be held not more than 3 days after the initial appearance. In the latter case, since the time for the probable cause hearing and the fact-finding hearing coincide, the two hearings are merged. Thus, the maximum possible detention under the section of a youth accused of a serious crime, assuming a 3-day extension of the fact-finding hearing for good cause shown, is 17 days. The maximum detention for less serious crimes, that again, assuming a 3-day extension for the good cause shown, is 6 days. These timeframes seem suited to the limited purpose for providing the youth with a controlled environment and separating him from improper influences pending the speedy disposition of his case. So this is reasonable, says the court. The conditions of confinement also appear to reflect the regulatory purposes relied upon by the state. When a juvenile is remanded after his initial appearance, he cannot, absent exceptional circumstances, be sent to a prison or locked up where he would be exposed to adult criminals. Instead, the child is screened by an assessment unit of the Department of Juvenile Justice. The assessment unit places the child in either non-secure or secure detention. Non-secure detention involves an open facility in the community, a sort of halfway house without locks, bars, or security officers, where the child receives schooling, counseling, and has access to recreational activities. Secure detention is more restrictive, but it is still consistent with the regulatory and parens patriae objectives relied upon by the state. Children are assigned to separate dorms based on age, size, and behavior. They wear street clothes provided by the institution and partake in educational and recreational programs and counseling sessions run by trained social workers. Misbehavior is punished by confinement to one's room. We cannot conclude from this record that the controlled environment briefly imposed by the state on juveniles in a secure pretrial detention is imposed for the purpose of punishment. rather than as an incident of some other legitimate governmental purpose. 4 more pages. Bear with me. The Court of Appeals, of course, did conclude that the underlying purpose of the section is punitive rather than regulatory, but the court did not dispute that preventative detention might serve legitimate regulatory purposes or that the terms and conditions of pretrial confinement in New York are compatible with those purposes. Rather, the court invalidated a significant aspect of the New York's juvenile justice system based solely upon some case histories and statistical study which appeared to show that the vast majority of juveniles detained either have their petitions dismissed before an adjudication or are released after adjudication. The court assumed that dismissal of the petition or failure to confine a juvenile at the dispositional hearing belied the need to detain him to fact-finding, and that, therefore, the pretrial detention constituted punishment. Since punishment imposed without a prior adjudication of guilt is per se illegitimate, the Court of Appeals concluded that no juveniles could be held pursuant to the section. There are some obvious flaws in the statistics in the case histories relied upon by the lower court, but even assuming it to be the case that by far the greater number of juveniles incarcerated under the section will never be confined as a consequence of a disposition imposed after an adjudication of delinquency. We find that to be an insufficient ground for upsetting the widely shared legislative judgment that preventive detention serves an important and legitimate function in the juvenile justice system. We are unpersuaded by the Court of Appeals rather than cavalier equation of detentions that do not lead to continued confinement after an adjudication of guilt and wrongful punitive pretrial detentions. Pretrial detention need not be considered punitive merely because a juvenile is subsequently discharged subsequent to conditions or put on probation. In fact, such actions reinforce the original finding that close supervision of the juvenile is required. Lenient but supervised disposition is in keeping with the Act's purpose to promote the welfare and development of the child. Even when a case is terminated prior to fact-finding, it does not follow that the decision to detain the juvenile pursuant to the section amounts to a due process violation. A delinquency petition may be dismissed for any number of reasons collateral to its merits on such as the failure of a witness to testify. Consequently, the final disposition of a case is largely irrelevant to the legality of a pretrial detention. It may be, so what the court was using was not even irrelevant, like data and statistics, relevant to the question. It may be, of course, that in some circumstances, detention of a juvenile would not pass constitutional muster, but the validity of those detentions must be determined on a case-by-case basis. Section is not invalid on its face by reason of the ambiguous statistics and the case histories relied upon at the court below. We find no justification for the conclusion that, contrary to the express language of the statute and the judgment of the highest state court, that this section is punitive rather than a regulatory measure. Preventive detention under the Family Court Act serves a legitimate state objective held in common with every state in the country of protecting both the juvenile and society from the hazards of pretrial crime. Given the legitimacy of the state interests in preventive detention and the non-punitive nature of that detention, the remaining question is whether the procedures afforded juveniles detained prior to fact-finding provide sufficient protection against erroneous and unnecessary deprivations of liberty. Matthew versus Eldridge. In Gerstein versus Pugh, 1975, which is a year before Eldridge, we held that a judicial determination of probable cause is a prerequisite to any extended restraint on the liberty of an adult accused of a crime. We did not, however, mandate a specific timetable, nor did we require the full panoply of adversary safeguards, counsel, confrontation, cross-examination, and compulsory process of witnesses. Instead, we recognize the desirability of flexibility and experimentation by the states. Gerstein arose under the Fourth Amendment, but the same concern with flexibility and informality while yet ensuring adequate pre-detention procedures is present in this context. In many respects, the Family Court Act provides far more pre-detention protection for juveniles than we found to be constitutionally required for probable cause determination for adults. I can't wait for them to tell us why. But I can tell you right now, keeping a child for 17 days is hardly an interference with anything that juvenile would potentially have to do, even if it meant missing their part-time job. Anyhow, so let's see. In many respects, the Family Court Act provides far more pre-detention protection for juveniles than we found to be constitutionally required for probable cause determination for adults. The initial appearance is informal, but the accused juvenile is given full notice of the charges against him, and a complete stenographic record is kept of the hearing. The juvenile appears accompanied by his parent or guardian. His right to be represented by counsel chosen by him or the law guardian assigned to the court. The initial appearance may be adjourned for no longer than 72 hours or until the next court day, whichever is sooner, to enable an appointed law guardian or other counsel to appear before the court. When his counsel is present, juvenile is informed of the charges against him. So there's your notice, and furnished with a copy of the delinquency petition. A representative from the presentment agency appears in support of the petition. The non-hearsay allegations in the delinquency petition and supporting depositions must establish probable cause to believe the juvenile committed the offense. Although the family court judge is not required to make a finding of probable cause at the initial appearance, the youth may challenge the sufficiency of the petition on that ground. Thus, the juvenile may oppose any recommended detention by arguing that there is not probable cause to believe he committed the offense or offenses with which he is charged. If the petition is not dismissed, the juvenile is given an opportunity to admit or deny the charges. At the conclusion of the initial appearance, the presentment agency makes a recommendation regarding detention. A probation officer reports on the juvenile's record, including other prior and current family court and probation contacts, as well as relevant information concerning home life, school attendance, and any other special medical or developmental problems. So let's consider. Opposing counsel, the juvenile's parents, and the juvenile himself may all speak on his behalf and challenge any information or recommendation. If the judges decide to detain the juvenile, he must state on the record the facts and reasons for the detention. As noted, a juvenile is entitled to a formal adversarial probable cause hearing within 3 days of his initial appearance, with the 3-day extension possible for good cause shown. The burden at this hearing is on the presentment agency to call witnesses and offer evidence in support of the charges. Testimony is under oath and subject to cross-examination. The accused juvenile may call witnesses and offer evidence of his own. If the court finds probable cause, the court must again decide whether continued detention is necessary under the section. Again, the facts and reasons for the detention must be stated on the record. In some, notice, a hearing, and statement of facts and reasons are given prior to any detention under the section. A formal probable cause hearing is then held within a short while thereafter, if the fact-finding hearing is not self-scheduled within 3 days. These flexible procedures have been found constitutionally adequate under the Fourth Amendment and under the Due Process Clause. A Appellees have failed to note any additional procedures that would significantly improve the accuracy of a determination without unduly impinging on the achievement of legitimacy purposes. Appellees argue, however, that the risk of erroneous and unnecessary detentions is too high despite these procedures because the standard for detention is fatally vague. Detention under this section is based on a finding that there is a serious risk that the juvenile, if released, would commit a crime prior to his next court appearance. We have already seen a detention of juveniles on that ground serves legitimate regulatory purposes, but appellees claim and the district court agreed that it is virtually impossible to predict future criminal conduct with any degree of accuracy. Moreover, they say the statutory standard fails to channel the discretion of the family court judge by specifying the factors on which he should rely in making that prediction. The procedural protections noted above are thus, in their view, unavailing because the ultimate decision is intrinsically arbitrary and uncontrolled. Our cases indicate, however, that from a legal point of view, there is nothing inherently unattainable about a prediction of future criminal conduct. Such a judgment forms an important element in many decisions, and we have specifically rejected the contention based on the same sort of sociological data relied upon by appellees and the district court that it is impossible to predict future behavior and that the question is so vague as to be meaningless. We have also recognized that a prediction of future criminal conduct is an experienced prediction based on a host of variables which cannot be readily codified. Since Judge Quinos of the family court testified at trial that he and his colleagues make a determination under the section based on numerous factors, including the nature and seriousness of the charges, whether the charges are likely to be proved at the trial, the juvenile's prior record, and adequacy and effectiveness of his home supervision, of his school situation, if known, the time of day, the alleged crime is evidence of its seriousness and possible lack of parental control, and any special circumstances that might be brought to his attention by the probation officer or child's attorney, or any parents, relatives, or other responsible persons accompanying the child. The decision is based on as much information as can be reasonably obtained at the initial appearance. Given the right to a hearing, to counsel, and to a statement of reasons, there is no reason that the specific factors upon which the family code might rely must be specified in the statute. The dissent would apparently have us strike down New York's preventative detention statute on two grounds. First, because the preventative detention of juveniles constitutes poor public policy, with the balance of harms outweighing any positive benefits, either to society or to juveniles themselves. And second, because the statute could have been better drafted to improve the quality of the decision-making process, but it is worth recalling that we are neither a legislator charged with formulating public policy nor an ABA committee charged with drafting a model statute. The question before us today is solely whether the preventative detention system chosen by the state of New York and applied by the New York Family Court comports with constitutional standards. Given the regulatory purpose of the detention and the procedural protections that impede its imposition, we conclude that the section of the New York Family Court Act is not invalid. Under the Due Process Clause of the 14th Amendment, the judgment of the Court of Appeals is reversed. And then there's going to be several pages of dissent from starting with Marshall and Brennan and Stevens. So you're looking at 10 pages of dissent and 11 pages of dissent. So I'll read that another time.